Walshe murder case. Evidence from the Karen Reed case could now be allowed in. Walshe's defense is bringing, basically, they want to talk about Michael Proctor. Why? Because he was involved in the Walshe case. And you remember Michael Proctor from the Karen Reed case. Here's a little reminder.
The witnesses that I had interviewed, the only individuals that I know or had met prior to this investigation was Julie, Chris Albert, and Colin Albert. These came from me. Funny, I'm going through his client's phone. No nude so far. I hate that man. I truly hate him. Yes, she's a babe. Weird Fall River accent, though. No ass.
Brian Walshe is accused of killing and dismembering his wife, Anna, back in 2023. Her body's never been recovered. Before we get into the hearing over Proctor's evidence, let's get you caught up on the case against Brian Walshe. For that, we'll turn to Court TV's Matt Johnson.
No comment from Brian Walshe after he was charged with the murder of his wife, Anna Walshe, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walshe was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walshe told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., Pap saw best tool to dismember. At 1:10 p.m., can you be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walshe came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walshe drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walshe drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walshe property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walshe was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walshe, as well as disinterring of a body.
All right, so the question, well, what's this got to do with Karen Reed? Well, are they blaming Karen Reed for this? No. Michael Proctor, he worked on this case, and the defense wants to talk about Proctor, and they want to bring in the texts from the Reed case, and they want to fill this jury in with Proctor's conduct during the Karen Reed case. So the judge is going to allow some of that. Let's listen to some of the arguments heard earlier this week from the defense.
Liebman seems to make it clear it's the Commonwealth's obligation to get materials from the federal government. There's no question when you read those 2 cases that is exactly what the SJC said way back in the 1980s. Secondly, the Commonwealth has failed to inform this court or any party what the exact basis is that they're relying on that says they can't review the documents in their possession and custody for Rule 14 information as defined by Rule 14. Now, I'll just say that when we were in Plymouth, they produced a December 2024 protective order. There was one they let us read it. We couldn't copy it. We had to hand it back. We did. There is a paragraph in it that seems to touch upon the issue at hand. But that paragraph, and I won't repeat it, but I think the government knows what paragraph it is, and it does not, in our opinion, prevent the government from reviewing the documents under Rule 14. It does have language that says you can't use the materials in any other case other than the Reed matter. But that's not what we're asking for. And for the government to continue to act like a paragraph that says you can't use materials in another case means they can't review them under their obligations under Rule 14 is creative thinking, creative interpretation, and it's simply running away from their obligations. And finally, the only other thing I have to say is what we've said repeatedly, and it was based on what the government told us beginning on July 17th when this issue became known. And that is, why haven't they explained then why Attorney McLaughlin, Assistant District Attorney McLaughlin, did in fact conduct some type of review of these materials and gave certain information to either the prosecutor in their office and our defense counsel. Now, granted, I was never told they gave substantive information, but they apparently gave sufficient information to either their DA or the defense attorneys. And that is not addressed, once again, in the government's opposition today. And I have argued that since I was told that on July 17th. And I'll just add that when we were before Judge Ferner, and she read that, and I understand that she cannot rule on this issue because of a judicial conflict, but she confronted the Commonwealth about that very issue. And the government refused to answer. And so I asked this court, why can't the government simply explain that? Why they did it in one case, why they provided information to either their DA or defense attorney in an unrelated case, and why are they simply refusing to do so now based on language they have not produced that, in my opinion, would not justify anything?
All right, that's the bottom line. Brian Walshe, there's so much evidence against him. Let's talk about it with retired FBI Special Agent Jennifer Coffindaffer. Good morning, good Friday morning, Jennifer. This is much ado about nothing, isn't it? I mean, let's face it. Okay, Michael Proctor was part of this investigation. There's a ton of evidence against Brian Walshe. Whether jurors are exposed to Proctor or not, do you think it's going to move the needle against the Commonwealth?
Well, first of all, when they look at Michael Proctor and you look at why he was fired, it was very clear. It was because he drank on the job. It was because he drove his police vehicle drunk, or at least after drinking, and because he acted inappropriately in his text messaging. Nothing to do with anything about evidentiary misconduct, such as fabricating evidence or otherwise doing something illegal with the evidence. And so that is why it doesn't comport with this investigation. This investigation was done right. And when you look at the 20 plus Google searches he conducted, formaldehyde, how to get rid of a body, what best tools to use to hack up a body. I'm paraphrasing here, but that's generally what was said. I mean, this is such a strong case, plus his actions going and dropping those bags of what ended up being indicia of the crime. It's a great case, and it shouldn't be convoluted with what Proctor said in those text messages.
Yeah, agreed. I mean, he's using his son's iPad. Can you recognize body if the teeth are bashed in? I mean, it's going to make jurors' stomachs turn and look at him and with a complete disgust and hatred. And it's funny, on that Zoom hearing, you can see sort of his wheels turning as his attorney is yelling at the judge because he's got old people syndrome on the Skype. Hello. You can see Walshe is like, hey, I wonder if we got a chance here. No, is the question. And you can bring Michael Proctor in or out. It's not going to matter. Likely, let's get a break. We'll have a little bit more of this. Plus, we're waiting for them to get up and running in Georgia for day 2 of the fascinating case that is going on there involving the daughter of a serial killer ends up murdered. The husband is on trial, but it's a cold case. Stay with us.
Matriarch of the Adelson family gets arrested.
Terrible.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins next week, only on Court TV.
Welcome back to Court TV Live. We are getting ready for testimony to begin in the case against Christopher Wolfenbarger. There's the clock. People are assembling. 9:30 is the start time. They're in Georgia, jury making their way to the courthouse. So as soon as the judge is on the bench and testimony resumes, we're all in on day 2 of this fascinating case. Meanwhile, we're talking a little Karen Reed, because we love talking Karen Reed, and it is kind of like removed a little bit. It's not Karen Reed, it's Brian Walshe, Massachusetts, Commonwealth, same investigator involved, Michael Proctor, we remember him. Well, this week they were hashing out what will and will not come into Walshe's trial in terms of Michael Proctor. So let's go back in and listen to more of this arguing via Zoom over this man.
The witnesses that I had interviewed, the only individuals that I know or had met prior to this investigation was Julie, Chris Albert, and Colin Albert. These came from me. Funny, I'm going through his client's phone. No nude so far. I hate that man. I truly hate him. Yes, she's a babe. Weird Fall River accent, though. No ass.
I do have one question for defense counsel in the Walshe case. Who's speaking on behalf of the Commonwealth in the Walshe case?
Your Honor, Tracy Custer for the Commonwealth on the Walshe case.
All right. So I have your response to the motion
Your Honor, a bit of housekeeping, if I could. That was a response to other motions. We received Mr. Tipton's motion to dismiss.
No, I'm sorry, I misspoke. This is a response to the motion for relief regarding federal materials. It's not a response to the motion to dismiss. But in your response to the motion for relief, you say the Norfolk District Attorney's Office is aware of its obligation under Rule 14. It's one of the last lines in your opposition, but you do not say whether you have or haven't complied with it. So I really don't know how you're interpreting Rule 14. How are you interpreting Rule 14?
Your Honor, we are interpreting Rule 14 as it is written, as we understand it to be written, that our obligation is to produce materials favorable to the defense, that our obligation is to, if we're aware of them, to inform the defense of those materials. We are aware of our obligations under Rule 14 in this matter, Your Honor.
But that doesn't really answer my question. We have unique circumstances here. Is it your view that even though these are nominally controlled by the feds, that you don't either possess them or have custody of them?
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter. And
so your position is even reviewing the documents, reviewing the documents in this context is not required by Rule 14?
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court order.
But that's a different question. The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
And is there anything you can cite to me that would support that position?
At this point, Your Honor, I would say there is currently a federal protective order. We are officers of the court. We are required to comply with that order. And I would suggest it is clear there's the balancing of that federal order and the Rule 14 requirements of which we are aware. In this case, I don't know if the court had a chance to read in detail the Commonwealth submission.
I did.
There have been prior TUI requests by both the government and by the defense in this matter. And again, the court has the response we received from that as well.
The TUI request, though, is a different question than whether the Constitution, Massachusetts Constitution or the federal Constitution or Rule 14 imposes on your office an obligation to review documents that you're in physical possession of. And I don't really, I know that, I don't want to say I don't care, but it's not particularly material to the question of what the Constitution requires of you that a federal prosecutor somewhere said, I wouldn't give it to you independently.
I understand that, Your Honor. At this point, I don't believe we are required to review those materials in violation of the federal protective order, but certainly I would ask for some time to respond to the motion to dismiss that was filed this morning.
Yeah, sure.
And again, if something, for example, if something was in plain view, that might be something that would cause a person reviewing those materials in the Reed matter to bring that to the attention of the federal authorities or to others to say they're aware of information in the custody of third parties. Certainly nothing like that has occurred in this case. No one has indicated they're aware of any materials in the possession of third parties.
Okay. I'll give you an opportunity to address the motion to dismiss.
That at this point in time, all of the Proctor chats or communications have been produced to the Norfolk District Attorney's Office outside of the protective order, and the Norfolk District Attorney's Office has provided those to all of the defendants who are part of this motion and will continue to provide those to other defendants.
That we do have an October trial date, and everything needs to be done expeditiously in the Walshe case at a minimum. I'll leave it at that.
The Commonwealth is mindful of the Walshe trial date and has expressed to the U.S. Attorney's Office that we are anxious to bring that case to trial and do not want there to be any delay, and we will be acting accordingly.